Welcome back to New Money. We're discussing estate planning. Guests Harry Joffe and Willem van der Merwe. If you'd like to email, you can send your email to www.bhca.co.za. Harry, please share with us the case you mentioned the other day where a couple got divorced, later reconciled and moved back in together. By the way, my parents did that. Just to let you know, they divorced after 25 years. They got together 9 months later, and they were then married for another 25 years. And my mother used to say we'd been married 50 years, and my dad used to rag and say it was only 25 years. So what are the implications of someone moving back? Firstly, we're thinking about paragraph 4Q, and then how do they still qualify? And then what about estate duty and income tax and all the things and donations?
All of that, yes.
Yeah.
So Bryan, I mean, you know, the Income Tax Act and the Estate Duty Act both are quite liberal in what they recognise as a spouse. So if you're in what we call the paragraph C definition of spouse, in that permanent relationship, which you can prove to SARS, then that will be recognised as a spouse for income tax and estate duty. I mean, your parents are a bit different, Bryan, because they moved back together and they got remarried, so that issue was quite clear. But the case I was talking about was they just moved back in. So they got divorced, reconciled, and moved back in together. And then they were asking me would there be a 4Q deduction if one of them passed away? And in theory, there should be, because they're now living together permanently again, and they should qualify. But of course, the problem is SARS is going to see a divorce certificate or a divorce order, and they're going to say, well, you're no longer married, you're an ex-spouse. And so what I was saying to the couple was they should make very certain and very clear that they've got documentary evidence and documentary proof to show SARS that they are living together permanently. You know, things like shared bank accounts, a same address where accounts are being sent to if there's paper accounts. There was even something someone suggested in the will, they should say in their will they are still leaving assets to each other because they regard each other as spouses or things like that. Problem, Bryan, is someone recommended to them that they do a contract. And I think they're a bit worried about doing a contract because they've already been bitten once, you know, they've already been divorced once. I'm not sure they want to commit themselves in a contract a second time. So it was quite tricky where they wanted to show SARS that they're living together as a permanent couple, but not put anything in contractual form because they're scared they might have a fight again and fall out again. I mean, Bryan, there's a famous case in the trust world, M versus M, from a couple of years ago, a Supreme Court of Appeal decision where a couple, the same couple, got married and divorced 3 times. So, I mean, that's the kind of thing that we end up now. There's some strange cases. So I think the point was here that you can expect queries from SARS, because SARS would see the divorce order, SARS would say you're an ex-spouse, not a current spouse. They would probably reject the 4Q. You're going to have to show SARS with documentary evidence that you still qualify because you are living together as a permanent relationship. And it's the same for donations tax, Bryan, and things like that. You're going to have to prove to SARS that you actually still are a couple, even though you were divorced.
Okay, then to Willem, whilst offshore trusts do offer significant advantages, Harry, Willem, to individuals, is there anything lately that we've got to understand that they should be aware of?
Bryan, it's always important for clients to have a good understanding of trust principles. And some of the important principles that we see is very important to highlight to clients is control. Clients need to understand that they are relinquishing control of their assets to the trustees. Now,
that's a hard thing. People don't understand that, relinquishing control.
And especially in the South African environment, Bryan, we find that clients want to retain control of their assets, but the principle of a trust is that you hand over control and that trustees are looking after the assets, but for the benefit of the beneficiaries. So you always have that trust principle that the beneficiaries should benefit, but that control element is a very important discussion. And then another important point is the cost of these structures, and Harry also alluded to it earlier. It's important for clients, if I go back to the analogy of the fence again, there is a cost element to maintaining and managing these structures, and it's important for clients to understand the cost, but to compare that then to the benefit that they get to protect the assets and to provide this succession planning.
Willem, you talk about a fence. In South Africa, we're renowned for building walls. And there are cheap walls and there are more expensive walls. I mean, through suburbs, I mean, people have put unbelievable walls up. So it's exactly the same with trust. I mean, there are costs, and depending on how elaborate the trust is, that can be, the costs will be involved.
Yeah, and that's why I like the analogy, Brian, because the more I think about it, the more overlapping there is. We often see that clients will say, I need to go one step further. I need a 24-hour security guard. But then they say the guard won't do anything, so I don't really want to pay for him. But he still needs to be there. He still needs to walk the perimeter on a daily basis. If something happens, you need to be there. And where another overlap is with estate planning, it's only that day when a perpetrator is there that you actually see the benefit of your estate planning. And you need to maintain it for that unsure day when you actually need the planning.
Great analogy. Harry, I had a question on the trust this last week, where we've invited someone to become a trustee, and the beneficiary or the settler is amazed that that trustee wants to charge 20,000 Rand a year. I don't think 20,000 Rand is a large fee at all. What is your feeling on that?
No, I mean, not at all. If you think what the trustee's got to do, where they've got to do the annual tax returns, they've got to do the annual reporting, and of course the trustee is now personally liable. If there's anything wrong in the trust's tax position, the trustee is personally liable, and there's also the anti-money laundering return. So I'm amazed a trustee will do it for 200,000 Rand unless it's a very, very simple trust.
Yeah.
I think, Brian, back to the cost story, we're finding, and again, no disrespect to any of the trust providers, but for many clients, an offshore trust just isn't worth it in terms of the cost. So, it's back to the fence scenario. If you've got a very small house and you don't have a lot of goods that you're worried about, or high value items, you're not going to need an expensive fence. And it's back to that same kind of principle. If you've got a smallish estate, and offshore, if you've got less than $5 million, that's seen as a small estate. You don't need an offshore trust for that. And most of the offshore trust providers, if you've got less than $5 million, won't even take you.
Well, Brian, may not take you today, but the past has been where they are, and I'm now starting to see enormous costs. I've got an email we'll deal with. I just want to get to one more question for you, Harry. When someone is no longer capable and the power of attorney cease to exist, why should one have to appoint a curator when you can appoint an administrator?
Yeah, so that's again through the Master's Office. If you want to get a letter of administration, the Master's Office have to give that. In terms of the Act, the Master's Office, there should be some restriction. I think it's R1 million estate size where the Master's Office can give you that letter. The Master's Office does give it for bigger estates. We've seen that. But you you take a chance at what that particular Master's Office will do. But I agree, Brian, if you can get the administration letter from the Master's Office, it's much simpler, much cheaper, and much easier. Getting a curator is an expensive process, and it often goes wrong. There was a case recently, Brian, where the individual over who the family were applying for curatorship order over came to court and said, I'm fine, I don't need a curator appointed, and the judge cross-examined him, and he was fine, and the judge threw the case out. So you always run that risk with the curatorship, whereas with the administration letter, a lot simpler and cheaper.
Okay. Well, I'm now going to get into our emails. First email is to you, Willem. It's from Philip, and he says, I have an offshore trust with my wife and children as beneficiaries. Can this trust distribute part of the assets to a trust in my kid's name, and what are the implications?
Brian, that is definitely a request that they can put to the trustees. Usually a trust deed will provide that the trustees can make a distribution to another trust that would be set up for some of the beneficiaries of that trust. So it's definitely possible to make that distribution to another trust for the benefit of the beneficiaries. And it will depend how the trust was originally funded, whether by donation or in some cases interest-free loans. But the standard principle is that the offshore trusts are usually in tax-neutral jurisdictions, which will mean that that distribution to the second trust should not have a capital gains tax implication. But it's very important to consider it on a case-by-case basis to ensure that is the case. The only other implication is that there would also be a cost involved. The trustees would have an administration charge for the distribution, setting up another trust, doing all the minutes, and all of that administrative tasks.
Okay. Then Edwin in Grahamtown says, Harry, I inherited money some years ago, which was held in a trust. However, I struggle to access funds as the trustees behave as if the money belongs to them rather than being for my benefit. Are trustees' fees regulated? And what steps can I take to ensure they respond to my requests instead of ignoring me? And why will they not transfer funds to a third party at my request?
Yeah, I mean, Bryan, this is an age-old issue. The trustees have to manage the money carefully and prudently, and they can't just pay money out if they're not happy that it's for a good cause, because they can be sued later on. So, I've got quite a lot of sympathy for the trustees in this kind of case, and we see it all the time, where, and I don't know the viewer at all, but he could be asking for money for a purpose which the trust doesn't allow for example. If he's not happy with the trustees, his best option is to go to the master and to ask the master to intervene. The master is reluctant to intervene with trustees. If he still doesn't get any joy, then he's going to have to go to court. But it's not a straightforward process.
Well, Willem, let me just ask you, if a trust, in other words, offshore trust can only distribute to beneficiaries, unless it's clear in the trust that there will be times I would like you to pay accounts or something like that. Is that correct?
That's the principle of the trust, Bryan, is that the trustees need to look after the interests of the beneficiaries, and they would look to make distributions to beneficiaries only. And that is part of the reason why they typically would not want to make transfers to third parties. You alluded to the exception that they might have school fees on behalf of a beneficiary that they will be willing to settle, but transfers to third parties is something that is very unlikely.
Okay. Well, you can never anticipate what the future holds. The only thing you can do is to ensure that your loved ones are taken care of long after you've passed on. The concept and advice behind estate planning is to help you make the right choices about securing the financial well-being of those who you leave behind. I hope that some of you watching our program this evening will embark on ensuring that you have reviewed your estate plan. To help you do this, Anchor has prepared a life file guiding you on information and documents that are essential for this program. And if you'd like to, you can download that life file on anchorcapital.co.za. It's on our website. Next week's program, we'll be dealing with investments. I'd like to thank you for watching. Willem, Harry, thanks for joining me this evening. I wish you all a good night.